The U.S. Constitution allows criminal defendants to act as their own attorney in a court of law. They're also allowed to question their accusers on the witness stand. But Senate Bill 603 by State Senator Ben Hueso would prohibit a defendant who represents themselves from cross-examining victims in certain cases. San Diego Deputy District Attorney Judy Tashner joins us with details. And Judy, the San Diego District Attorney's Office actually backs this bill. What would SB 603 change?
Well, it would provide a protection that is not currently in place to protect the most vulnerable of victims in the courtroom from being directly questioned by their attacker. It would apply to the most sensitive of cases: felony domestic violence, felony sex crimes, felony child abuse, felony elder abuse, and felony stalking.
So when you say their attacker, this is actually the defendant who is who is being accused of this. Why do you think this bill is necessary? Are there a lot of defendants who represent themselves in these types of cases?
It doesn't happen in a large percentage of cases. It's a pretty small percentage of cases where a defendant chooses to represent himself. But when it does happen, and in these particular cases, it can be horrendous. And so we are trying to protect them in the most serious of cases.
And has that happened in a case that you've prosecuted where you've seen somebody representing themselves cross-examining the victim?
Yes, I mean, two cases recently come to mind. One was a stalking case, and where she had to answer questions directly from her stalker, and another was a rape case that occurred here in San Diego, where our rape victim had to answer questions directly from the man who eventually was convicted of committing a really violent rape upon her. And he was representing himself, and she had no other option, despite the fact that she was having panic attacks and was having to go to the emergency room before the trial.
What kind of, I was going to say, what kind of impact? That's impacts on the victim, of course. What about on the court? What about on the jury?
Well, juries have to sit and listen to this, listen to the accused directly question the person who supposedly they raped or molested or stalked, and I would think that could be pretty emotional and uncomfortable.
Well, the ACLU opposes this bill. Earlier today, they told us this by phone.
The U.S. Constitution guarantees to every person the right to represent himself or herself, and it also guarantees the right to effective cross-examination. And the procedure proposed here of bringing in an attorney who is not involved in the case to read a list of prepared questions is not effective cross-examination. And so while we understand the good intentions here, this procedure is simply not consistent with the Constitution.
So what is your response, Judy, to the constitutional rights of a criminal defendant to cross-examine their witness?
Yes, it is being opposed by the ACLU, and we've had this discussion during a Senate hearing, and I'm aware of their discussions, their arguments that saying that this is it's going to violate the constitutional rights. But we've researched this. We have pulled case law from other jurisdictions where this has been upheld, this exact procedure. Our own Supreme Court has said that if you have a compelling state interest, it can outweigh a defendant's rights in some cases.
What about the idea that if you do not allow the defendant to ask the questions, to cross-examine on a court of law, that you're implying that defendant is guilty before the jury?
He still remains innocent until proven guilty, and that's going to be up to the jury to decide. This is simply another criminal procedure to put in place, and the jury will be told you're not to use this against him. It's a criminal procedure that the judge is putting in place.
Yeah, and under SB 603, who would then question the witness if it wasn't the defendant?
If the judge finds that having this defendant directly question this particular victim would cause that victim further trauma, the judge could call up a standby counsel would come down and read that defendant's questions. The defendant would still get all of his questions asked, he would still maintain control of his case, and he would still get to have all of his questions asked through the standby counsel.
Are there any safeguards right now in place for the victims in either other states or other jurisdictions?
Nobody has this law as far as what we've been able to find, but other jurisdictions have case law that has upheld it. And in cases that haven't been upheld, they essentially stated that the judge didn't make the correct factual findings first. And so that's why we think this bill is so important, because we've looked at all the cases and what they've said, and we've got the correct procedure in place to make sure everyone's rights are protected, the vulnerable victims' rights as well as the defendant's rights.
All right, San Diego Deputy District Attorney Judy Tashner will be following up on this. Thank you.
Thank you.